50% of you have an approval process. And I think it was something like 80% the business gets in the way of getting to destruction, and it was 70-some% that the attorneys are a barrier to getting to destruction because of the approval process. So Ken, from your enlightened and maverick perspective, tell us about the, if 2 parts. We have our process, we defined our process, we want you to approve it, and we want to be left alone to be adults and follow the process in an appropriate way. And the second is, do we really need to come back and obtain approval?
Well, all right. We have a process, we've all agreed on the process, everybody's bought into the process. The process is the process. That's first of all. And that creates assumptions. And the assumption is the process will be followed.
And that the process is good.
And that's the process is good. So let's say we have a scenario that at the end of the life cycle of some large corpus of information, whatever it is time for that information to go. Do we have some sort of final checkoff that it's going to go? In a sense, we do have a final checkoff. That's actually your next box down there. There should be a final checkoff, the same way that no corporation has only one person in charge of writing checks, that before the check is signed by someone, it's gone through an approval process.
Our process has checks and balances.
Your process has checks and balances built into it. Nobody, particularly not legal, should have veto power, and particularly a pocket veto. A pocket veto meaning that if they do not positively sign off saying, yes, this stuff is going to sit around forever and ever. The saddest moment of my life as a lawyer back in my own records management days was walking into a warehouse in 1992, seeing rows and rows of boxes saying, destroy in 1985. And they were the whole warehouse full of them. And they were, we're talking 38 million items that couldn't be destroyed because no one would put their signature on the line. So the presumption is that the process will be followed. If there is someone in legal who believes that for some reason the process needs to be abrogated, I can't imagine why, but they better make a very strong business case for that. Because I'm assuming that, that if the process has been followed, that if there is anything that's subject to a litigation hold, that's already been sequestered, removed, or collected, or copied, and that's not part of it anymore. If they're now saying at the end of the process, no, we have to look through all of this stuff one more time, that means that they didn't do their job the first time. And I'm questioning their competence. So they got to make a very strong business case to overcome the presumption that this is going to be destroyed in the routine course because that's our process and everybody's checked off.
And the way you sell that as records managers is you say that if we don't take Ken's approach, which I think is the appropriate approach, we are actually making our position for purposes of litigation worse. Because if the other side finds out that we're making a document-by-document subjective discretionary call, we're actually inviting more motion practice. You are, ironically, you are in a better position to defeat a spoliation motion if you're spoliating. And by that I mean if you are following a routine policy. As soon as you allow legal or someone else in the organization to make these discretionary calls, you are immediately putting yourself and your organization in a position, you are inviting to be second-guessed.
Yes, and in my scenario of walking into the warehouse and finding stuff that should have been destroyed 7 years before, it meant that we now had to spend another $1 million in that litigation reviewing stuff that we knew had no relation whatsoever to the litigation, but we now held it. It was there. We were now under an obligation to review it.
And the other thing, too, is judges. We're lawyers, and we tend to be somewhat risk-averse, too. And if you come to me, if the other side comes to me and says, well, Judge, they've acknowledged that they saved it. One reaction from some jurists would be, well, since you saved it anyway, let's go to the trouble and the time and the expense of searching through it. Because after all, you decided to save it. Don't blame me, you saved it. Now search it. And so you become your own worst enemy if you start making these discretionary calls. If you feel comfortable with the policy, then feel comfortable in following the policy.
And that, Judge Shaffer, you hit on a very good point. Whenever we establish retention, and I realize we're a house full of records management professionals as well as IT and legal, but we make sure that it's a policy based on not the content that's there as far as whether it would help us or hurt us, but the function or the business process to which all of that content relates, and we treat all of it based on business function or business process. So you hit on a very good point. I appreciate that.
There are two other things flow from that in terms of the notion of having the legal department have a veto power. First, legal departments are not in existence to veto business policies. That's not what they're supposed to do. Second, from the standpoint of any sensible lawyer, I'd rather you own the problem than me. And if I have the final say, then I own the problem. This is why all those boxes were in the warehouse. A sensible lawyer ought not to object to a records retention policy being run by the business side, so long as in preservation situations, the legal voice can be heard.